So again, welcome everyone. Thank you for joining us tonight. So we're going to be talking about tools for teaching about Supreme Court cases. We're going to be focusing on a pair of cases that are set to be argued in front of the Supreme Court in less than 2 weeks. 2 weeks from yesterday is when they are set to hit oral argument. As you're joining us this evening, if you want to let folks know where you're joining from and what you teach, if you're a classroom teacher, that would be spectacular. The goal tonight is to get to know each other a little bit, to be able to do some professional learning, ask some questions, and most importantly, come away with some resources that you can use in your classroom. So, like I said, we'll give it just another minute or so, and then we'll get started. All right. All right, we have a nice East Coast contingent joining us this evening. Oh, there we go. We have somebody from the center of the country. Megan, thanks for joining us. And I see Jen teaches AP Gov. Wonderful. I was a longtime AP Gov teacher myself in Madison, Wisconsin. My favorite class of all time to teach. We definitely have some things set and ready for AP Gov teachers, along with plenty of other folks too. Wonderful. Again, if you're just joining us, feel free to introduce yourself. Let us know where you're joining us from and what it is that you teach. And Alexa, I would love to know more about your personal law class. I wonder if you use the street law textbook. Okay. All right. All right. I think we'll go ahead and get started, and we may have some additional folks join us. Welcome. My name is David Olson. I'm the Director of Education at Retro Report, one of your co-hosts this evening. I'm joined by Kathy Ruffing, who's joining us from Street Law. And tonight we're gonna engage in some wonderful professional learning and find some fantastic, very free, very usable classroom resources to teach about Supreme Court cases in general. And for those of you who are aware of some upcoming Supreme Court cases dealing with affirmative action, we're ready to dive in on those cases as well. So first thing I'll say is we're very happy to share all of these resources. I will be following up with everyone with an email that includes all the links to everything that we share tonight. You should expect to see that from me tomorrow morning. If you're one of those people who loves to follow along with a presentation, you certainly can. The bit.ly is there at the bottom of this presentation if you want to load that up and sort of look through while we go. There really aren't many surprises there. There's nothing that you're going to spoil for yourself by looking ahead. But yes, feel free to check it out. And again, when I send it out later, feel free to go back and dive in a little deeper. Like I said, my name is David Olson. I'm the Director of Education at Retro Report. I'll tell you a little bit more about Retro Report in a moment, but I've been in this position now a little over a year, helping do outreach with educators, helping create materials for classroom teachers. And prior to that, I was a longtime high school social studies teacher, taught AP US government and politics. I taught a criminal justice class, US history, world history, all sorts of different things. And joining me tonight, I'm very happy because I love street law materials. Joining us tonight is Kathy Ruffing.
Hi, I'm Kathy Ruffing. I have a very long title there, but basically I do the teacher stuff at Street Law. I have a very similar background to Dave. I retired about 4 years ago from Fairfax County Public Schools in Northern Virginia, where I taught for 27 years. And I taught AP Government and a law elective for most of those years. I see some FCPS teachers in the queue today, so nice to have you with us.
Wonderful. So our goals for this evening is that we're going to examine some of these resources specifically for teaching about Supreme Court cases. Some of the things that you'll come away with this evening are some new videos, including one from Retro Report that we actually released just a few hours ago. So you're going to be amongst the first people on the planet outside of Retro Report staff members to see it. We have some tools to do some different document analyses, particularly Supreme Court cases. We'll talk about some moot court simulations, and then provide sort of a starting point for analyzing affirmative action in particular. A lot of the things and approaches that both Kathy and I will talk about tonight can be applied across Supreme Court cases. But one of the wonderful things, and one of the reasons why I reached out to Kathy and Street Law in particular, is there is an upcoming Supreme Court case. Like I said, it's going to be argued 2 weeks from yesterday, and it could potentially upend the precedent as we know it regarding affirmative action in higher education. And so our goal tonight is to help all of you do some professional learning and really to be able to confidently bring this issue to your students and to the classroom. Certainly, you might have a student or two, perhaps a whole bunch of them, who are really eager to learn, what will the new rules regarding affirmative action be, since it may well impact their ability to get into the school that they want. So we're going to be talking about these two companion cases, the Students for Fair Admissions cases. So I know I see a lot of familiar and friendly faces in the audience. So my information about Retro Report will certainly be brief here, since at least some of you are familiar. Retro Report is a nonprofit, nonpartisan journalism organization. So what we do is we tell stories, and we tell stories in the form of short form documentaries. The vast majority of our films are in the 7 to 12 minute range. So they work really well for integration into a lesson, to be a springboard for a discussion or an inquiry activity. Our films and what we focus on with our storytelling is connecting past and present, of figuring out what are those stories of the past that need another look, or those things that we're grappling with in the present. What's the history behind it that helps us understand the moment that we're in? Our full library, which is over 250 films and growing by the week, is entirely free on our website. There's then a subset of those films, now about 90, and that one will be growing as well by the week, that have some classroom resources to accompany them. So that ranges from some discussion or comprehension questions all the way up to full-blown lesson plans, student activities, some of which you'll see this evening. And then I'm very pleased, we just loaded it today. We have a brand new U.S. Supreme Court collection. So not only the affirmative action case and video that we're going to talk about is there, but plenty of others that I'll provide you a sneak preview of as we go through. All right, Kathy.
Sure, and I'll give you a little brief history and a little introduction to Street Law if you're not familiar with us. So we kind of have a funny name. We are 50 years old this year, and that name came from our original program, which was Georgetown University law students realizing that there was a need to go into DC public schools and teach students about practical law. Things that could affect them every day, namely their rights and how to deal with the police and things like that. So that's how we started. We've grown a lot since then. We are now a global, nonpartisan, nonprofit organization. We do a lot of work around democracy education, rule of law education, and of course, have a focus on all things Supreme Court, which is what drew me to the organization. So that's what we do now. We're in like 40 different countries and all over the United States. And just like Retro Report, our mission is really to provide teachers with free access to really quality materials to be able to make their lives a little bit easier, we hope.
Wonderful. So again, The goal tonight is for all of you to be able to walk away with some resources that you can use in your own classroom directly with students. So we'll start with one of those resources. So Retro Report, just about a week ago, we released this film that takes a look not only at the context of these cases that are set to be argued before the Supreme Court, but also a brief look back in history, or not in the not too distant past, to take a look at how did we get to this current moment with the jurisprudence around affirmative action. So in total, this is a 10-minute film that connects both past and present. I'm going to show you about a 2.5-minute chunk, and then we'll talk about some of the resources that go with this. The first person that you're going to hear from is the lawyer who has brought a number of different lawsuits challenging affirmative action programs. I don't know if we have anyone joining us from Texas this evening, but if you remember back to a few years ago, the UT Austin affirmative action challenge that was brought by the same lawyer as the current challenges, both of the Students for Fair Admissions who are joining us. I'm sorry, I was distracted by the very cute child that has appeared on camera. So we're going to watch about a 2.5-minute clip of this, and then we'll check out some of the resources that go with it.
You cannot remedy past discrimination with new discrimination.
Bloom's case has deeply divided the Asian American community.
We are united today to protect opportunity. Bloom's lawsuit is racist in its effort to whitewash history.
We're still a minority at the end of the day. Asians have been discriminated against. I would hope that as a minority, as an Asian American, we're not the ones losing out.
But Bloom's lawsuits have also reopened the larger debate, one that the Supreme Court famously grappled with in 2003 in a case called Grutter v. Bollinger.
For the first time since the 70s, the Supreme Court today took affirmative action in education dead on. Can race be a factor in college admissions, period? Two white females say the University of Michigan denied them admission using tough standards for whites.
They say things like we're selective, but they're making selections on racial lines.
I think that the University of Michigan is using a preference that is based solely on skin color, and that is wrong.
A position shared by more than 2/3 of Americans, according to a Newsweek poll. 68% said they opposed racial preferences in college admissions for blacks. 70% said they opposed preferences for Hispanics.
Those who were challenging the affirmative action program were arguing that there was something deeply offensive about counting and sorting people by race. On the other side, of course, was, look, it's been working. Without it, we'd be back to where we were. So these are two profoundly different ways of looking at the problem, and it came at a very important moment in the court's own evolution.
At the center of that court was a conservative former politician who had overcome discrimination to become its first female justice, but struggled with the question of affirmative action. Her name was Sandra Day O'Connor.
People paid a lot of attention because these issues of race really touched deep chords in the American fabric. One issue with affirmative action is that somebody gets a benefit on the basis of race. That means that if it's a zero-sum game, somebody, because of their race, didn't get that benefit. And that really bothered her. I think she very deeply grappled with the issue that was presented in Grutter and the deeper issue about the role of race in American life and American law.
That was the preview there. So now let's check out some of the resources that go with it. So again, that was about a 2.5-minute chunk of the full 10-minute film.
You cannot.
So there's actually we've constructed a number of resources to accompany this film here. A full lesson and student activity that has students utilizing the film, but also a look back in history to analyze a portion of the Grutter case. I also realized as this film was being produced that for a number of years in the classroom, I was pronouncing the name of this case wrong. Forever, I had been pronouncing it Grutter, but that is not how Miss Grutter pronounces it. So here, sort of the central question is, how has the court viewed affirmative action? And then what are some of the things that makes this case different? And I know some of the resources that Kathy will share, looking at how to parse some of the different arguments, I think shed some light on that as well. Some of the intricacies, as there's another legal challenge here. How is it different? What's the different flavor of legal challenge this time around? One of the other things that you'll see in the lesson that I'll show you here in a moment is there's a little section looking at amicus curiae briefs. One of the other parts of this video that comes just after what we saw dives in a little bit deeper into Justice O'Connor's decision. She writes the majority decision in Grutter. And one of the things that Justice O'Connor focuses on is the impact of some amicus curiae briefs from both CEOs of Fortune 500 companies along with the US military, who argued for the importance of affirmative action program. This is something, and I'll probably mention this more than once this evening, but when I was teaching AP Gov, I used the street law, SCOTUS in the classroom, moot courts on a regular basis. And we would divide up, students would have different roles. We'd have a team of attorneys for the both sides. We'd have 9 justices, and then we'd have other students who were filling in as friends of the court. And their job would be to write an amicus curiae brief. And I don't think I ever did a fantastic job of explaining to students not only what an amicus curiae brief is, I think that part I did okay, but maybe what the potential power is of an amicus curiae brief. And I think that Grutter case is a perfect example where an amicus curiae brief ends up carrying quite a bit of weight in the end. There are also some additional resources that I'll show you here in a moment. I've gone through and chunked out an excerpt of Grutter v. Bollinger that has both O'Connor's, a segment of O'Connor's majority opinion, and then also Chief Justice Rehnquist's dissenting opinion, so that students can wade through, and a case briefing activity that goes with that. And then another definitions activity, which I'll show you here as well. So to orient yourself, this is the education library at retroreport.org. So this site houses all of our different films and collections and classroom resources. So here, the brand new US Supreme Court collection. It has our affirmative action case and film right up top, along with another film that I'll tell you about here in a moment. But as we go through, one important thing to know: when we create new lessons and activities for use in the classroom at Retro Report, we create them in Google Docs. The goal there is to make it as easy as possible for you as the teacher to go through, make a copy, and then make whatever changes you feel are necessary for use in your classroom. As someone who very regularly had 2 computer screens, I had the PDF that I wanted to copy from and steal questions from, and then my own document that I was building. There was way too much of that happening in my life. So if I'm going to be on the side of creating materials that other teachers are going to use, I want it to be as easy as possible for teachers to go through and say, yep, this is the chunk I want to use. I don't like Dave's question, so I'm going to put in a different one here. I'm going to ask a question that connects to what we were talking about yesterday, or things like that. So here, the way this student activity starts, so this is the student-facing document here. It allows students the link to go watch the film. There's a handful of questions that go with the film directly. And then as we go through, there's a couple other resources that we've included. So one is this very brief article, Why and When to File an Amicus Brief. So here, I think this article does a very good, succinct job of explaining what amicus briefs are, what their purpose is, and then connects it back to the film to ask, well, how did the briefs in the Grutter case influence Justice O'Connor? And then the last portion of this student activity has students go back and read a very short segment from Grutter v. Bollinger and ask a handful of questions. I think one of the things that stood out to me in the Grutter decision that will almost certainly come up in the Students for Fair Admissions cases and will probably stick out to your students is this line from Justice O'Connor in her decision, where she says, "We expect that 25 years from now, the use of racial preferences will no longer be necessary to further the interest approved today." Well, in 2022, we are not quite 25 years past. So the Grutter v. Bollinger case was 2003, but we can see it in the distance. And certainly the students who are in front of you, some of which who might be, graduating from high school right around that 25-year mark. I think it's certainly a great question to ask your students and to reflect on. So frankly, that's the last question that students go through in this activity is Justice O'Connor has said she doesn't think, she thinks there will be a time where these racial preferences are no longer necessary. I want to hear from your students. I want to know what they think and why. What's their reasoning about whether or not they think racial preferences in higher education admissions are necessary. A few other things here. So this is the longer case excerpt from Grutter v. Bollinger. So this one I went through, took out some key sections. This total excerpt is under 3 pages. If we go through on the 3rd page, it includes an excerpt from the dissent by Chief Justice Rehnquist, joined by Scalia, Kennedy, and Thomas. So this was a 5-4 opinion when the Supreme Court makeup was a little different than it is today ideologically. And so it'd be, perhaps your students can make some predictions between now and what likely will be the last week of June. Kathy may even be in the courtroom when they announce the decision on this one. So here there's the excerpt from this case from Grutter v. Bollinger. One of the things I always love to do with my students, and particularly when I taught a criminal justice class, I was not lucky to have the street law textbook. So our texts were always Supreme Court cases. They were primary source documents. And so what we did was we learned how to brief a case, something that I learned how to do in high school. And then when I was in graduate school, I took as many classes at the law school as I could. And this is the common practice, right? This is how do we organize materials? How do we organize our thoughts in a logical way looking at Supreme Court cases? And so here there's a template to have your students use to sort of walk through the case and gain the essential ideas. I try to keep it here to 1 page. And if you're like, whoa, Dave, I'm not quite sure where to start here on this one, there is a wonderful short article that I would use at the beginning of every semester with my criminal justice students. I've provided a link to it, but you can also find it freely available online through a Google search. There's this short article called How to Read a Legal Opinion, a guide for new law students. And my favorite part was telling my sophomores, juniors, and seniors, guess what? Now that you're in this class, you are officially law students. So now let's learn how to read a case. And so here, it's 16 pages, but I can guarantee you don't need to use the whole thing. I would often use the first 2 to 3 pages with my students. It goes through what's in a legal opinion. How do we figure out the name? What does the name of a case mean? What is a case citation? And then the most important parts here are, what do we get when we step through the facts of the case and then the legal opinion of a case, to begin to really go through this exact format of how do I pull out pertinent information while reading an entire Supreme Court case, or more than likely an excerpt of a Supreme Court case, to figure out, what is this about? What's the central question? So those are a number of the activities that go with the affirmative action case. There's one other one in our process at Retro Report of conducting all of these interviews for our film about affirmative action. we had the opportunity to talk with a number of amazing legal scholars. And part of what we did was we asked a number of them the same questions. We asked them to help us with some definitions. So we've created some very short films, either for use with your students or for those of you who are like, oh man, I'm going to have to explain what strict scrutiny is. I need some help on this, right? So here we have a very short film asking the question, what is affirmative action? That one obviously more applicable if you're teaching about affirmative action, but then if you're teaching about a whole host of other cases, whether they be cases looking at race-based restrictions or First Amendment issues, we have a short film asking the question or answering the question, what is strict scrutiny? And then breaking it down even further to those two other components for strict scrutiny, which is what is a compelling state interest, and finally, what is narrowly tailored. So here we've also created an activity to go with this. So if you're one of those people who's like, yep, we delve deeply into the law in our class, we have some stuff for you. So here, this activity looks at the levels of scrutiny. I've filled in most of the things for rational basis, or the things for rational basis and intermediate scrutiny. If you were adapting this to your own classroom and wanted to make students, maybe do a jigsaw activity or find some of these additional components, well, go ahead, make a copy and empty some of these boxes in the table and say, yep, that's on you students as well. So here, this has students go through, it gives them the information for rational basis and intermediate scrutiny, but then based on the film and those definition films, has them go through and figure out, well, what do we mean by strict scrutiny? And then to try to summarize and coalesce what the differences are between those. And then taking a closer look here at what is a compelling state interest and what does it mean for something to be narrowly tailored. So another quick look here, that's all the stuff that goes with the affirmative action case, and there's quite a bit. The rest of the materials here, and I'm going to finish in about 2 minutes here and turn it over to Kathy, is the other films and resources in our Supreme Court collection. So here, the film that we just released hours ago takes a look at the legacy of the Korematsu decision. So it's titled How a 1944 Supreme Court Ruling on Internment Camps Led to a Reckoning. And not only does it look at the Korematsu decision in its time, but it follows really what happens after, through the 1980s, and still how we're looking at these things today, and sort of grapples with the question, what do you do with a Supreme Court case that even the current Chief Justice has said was wrong from the start? So there is a brand new activity that goes with this one as well. It's heavy on primary sources. Ask students to dive into Executive Order 9066, which authorizes the creation of military areas. Has students watch the film. There are some amazing human beings in this film, including a 102-year-old Yai Wada, who is interviewed for this film. If you didn't know she was 102, you'd never know it. You'd think the woman was maybe in her 70s. She is absolutely amazing and definitely worth a watch. And then has students go through an excerpts from the Korematsu decision. And then what I thought was amazing from this film is there was actually evidence that the US government lied about the evidence it had of potential saboteurs and people who may be trying to help the Japanese on the West Coast. These were key elements that the Supreme Court relied on in making their decision in Korematsu versus the United States. So please, I invite you to go through, not only watch these videos, but go through and check out some of these other films here. We have ones on the Pentagon Papers, on Citizens United, on gerrymandering, on busing, on Bush v. Gore, on down the line. So here you'll also find a number of films that also, we have a handful of AP government FRQs, including some SCOTUS comparison FRQs. All right, I'm at my time. Kathy, turning it over to you.
Okay, I'm ready to go. So once you use all of Retro Report's really fantastic resources on Grutter and strict scrutiny and rational basis and all those things, you'll be ready to take a really deep dive into these two current cases. So street law, one of the things we're really known for, not the only thing we do, but we write many, many case summaries, and most of them are about current cases before the court and, you know, the ones that were argued in recent terms. Sometimes we do landmark cases. We also co-host landmarkcases.org with the Supreme Court Historical Society. So we have landmark cases on there. But all of our case summaries are really formulaic. So most of them have a background section that does a lot of what actually Retro Report has done for us for these cases, that gives students a really good grounding in the issue itself, in this case, affirmative action in admissions and strict scrutiny, stare decisis, things like that. And then the facts of the case itself, the issue before the court. And then we give students excerpts from constitutional provisions, applicable legislation, and important precedents, so they have the tools to be able to look at the facts and the issue and be able to come to their own conclusion about what the answers to those issues should be. We outline the arguments from both sides of the case. And I want to make the point, because I think sometimes people think I make these up. They come from the briefs. I read the briefs. I read both, they're called the merits briefs, the briefs of the parties themselves. And then I read a lot of the amici. And the arguments only come from the merits brief. So these are the arguments that the both sides are bringing to the court. And of course, we're writing them at a level that hopefully is much more accessible for your students. We're trying to write them at about a 10th grade reading level. We don't assume any legal knowledge of either you or your students. So if we use a term like strict scrutiny or stare decisis, we're going to define it and make sure you know what it means. And then when a decision and opinions are available, we add those. So they're not there now because we don't have them yet. And as Dave said, we probably won't have them from these two cases for quite a long time. So our case summaries are all very formulaic because we have a lot of different activities that you can take those sections and use them sort of like ingredients and put them together in different ways, like different recipes, to come up with 7 really classic activities that you can do. And one of the links that you'll receive from Dave in a future email will be to a much longer document that talks about all 7 of these and how to take the different parts of a case summary and use them to be able to do these activities. Tonight, I'm pretty much going to talk about classifying arguments in the moot court. So I'm going to expect you to read this, first of all. Don't be like, oh my God, she expects me to be able to read that tiny little writing. I just wanted you to be able to see sort of what this case summary looks like. So this is the one for Students for Fair Admissions v. UNC. It has a much longer background section than most of our cases have, because there is quite a bit of background that students have to know to dive into this topic. This is obviously a racially charged topic. It's a contested issue that people feel really strongly about on both sides. So important for them to, have an understanding of the underlying base legal issues behind it. So the background is the first section, and the background has, among other things, a discussion of strict scrutiny, which I'm not going to talk much about because I feel like we already know a little bit about it. But you can understand how it would be really important for students to grasp strict scrutiny to be able to really look at these cases and decide what they think their answer would be. And again, the keys are exactly what Retro Report has focused in on in their definitions, a compelling governmental interest and narrowly tailored legislation to make sure that it achieves that interest and also that it doesn't interfere with the rights of others. Another really big issue in this case is stare decisis or stare decisis, or however you want to say it. It's Latin, it's a dead language. If you listen to the justices, you can hear them pronounce it all sorts of different ways, sometimes the same justice, different ways. I'm going to use stare decisis. But this is a big deal in this case because there is a clear precedent Most people agree. And so one of the main issues in this case is, should that precedent be overturned? And if you, unless you've been living in a metaphorical cave, you know that last term there was a big case that involves stare decisis, the Dobbs decision. And so this is it's a big issue now with the court, frankly, about when should precedent be overturned. So this will help students to have some background in that before they dive into this case. And then the next section is about the facts of the case. So the students are going to learn what is UNC's admissions policy. And I just thought it might be an interesting hook for them that UNC uses the Common App, because probably a lot of them are going through this process right now. Probably a lot of them are very familiar with the Common App. They've probably answered this question, which you can see as it appears on the Common App. And then UNC has this process. I won't get into it in detail, but because the case summary does. But essentially, they look at all sorts of criterion. They rate some things, but they don't rate race. They don't have a formula, and they're looking at things very holistically, or at least they say. And according to them, race only plays a meaningful role in a very small number of cases. But so one of the things we always do in our case summaries is to make sure that you understand both sides of the issue. So enter Students for Fair Admissions. And again, I think the video that you saw will give you a nice grounding in who this group is and what's behind this group. This is their mission statement from their website, without any kind of editing or editorializing on my part. But they come on the scene in 2014 and immediately sue Harvard and UNC. So our case summaries will also tell the students sort of the legal beginnings of these conflicts, right? So everything starts with some kind of a conflict at a lower court stage, except for original jurisdiction cases, but we don't really write those. So, they'll learn about this original lawsuit where Students for Fair Admissions alleges that race is often a factor in which students are admitted at UNC, and that UNC did not seriously consider race-neutral alternatives. So I haven't talked yet about Grutter, but when we do, we'll see that that's a part of that decision, is that because of that quote that Dave gave you from Justice O'Connor, that this was supposed to go away, right? We weren't supposed to keep this process forever. It was her vision was that it would phase out. So it was going to be really important for schools to consider race neutral alternatives. So finally, after 7 years of court proceedings, there's finally a case, an actual court case, and the court finds in favor of UNC. And basically, get back to everything comes back to strict scrutiny. They said that they satisfied strict scrutiny and they applied the precedent of Grutter. Pretty much immediately, 2 days, SFFA appeals to the Court of Appeals, which is, not uncommon, but then this really is uncommon. If you're using cases to help your students understand the path of cases take to the Supreme Court, this is really pretty unique. It pretty much simultaneously petitions the Supreme Court and says you need to take this case before the lower court has heard it, which for those of you who know anything about granting cert, doesn't happen very often. But their reasoning is because the court had already granted certiorari and the case Students for Fair Admission v. Harvard, and they wanted these cases argued together, or at least alongside each other. So the court granted cert to both, and originally they were consolidated cases, which means they were going to be argued and likely decided together. But then Justice Jackson joined the court, and she sits on a board of Harvard. So she had said in her confirmation hearings, and then later did recuse herself from the Harvard case. So I can't say that's why they divorced the cases, but they did. So now they'll be heard on the same day, as Dave said, but they will be heard separately, with the UNC case being heard by a full court including Justice Jackson, and the Harvard case being heard by an 8-member court because she's recused herself. So the next section in the case summaries are the constitutional provisions, legislation, and precedents. It's kind of not a catchy title, but they lump together. So all the things the students are going to use to apply to the case to make their decision. So in this case, we have the Equal Protection Clause of the 14th Amendment. We always try to put the actual language of the legislation, but we'll excerpt it down to where they can really focus on the part that's going to be at issue in this case. The next part is Title VI of the Civil Rights Act. So this is the part that says that what you can read, but that no one will be discriminated against under any program or activity receiving federal financial assistance. So if you kind of focus with your students on the fact that the Constitution applies to like the government and the 14th Amendment applies to what the government can do, this is the part that makes it apply to UNC, which is a public university, and even Harvard, because Harvard receives federal financial aid. So we have 5 precedents in our case summary for this case. Brown v. Board of Education, which might surprise you, but actually the Students for Fair Admission uses that case, really relies on Brown and evokes Brown a lot in their argument. Regents of University of California v. Bakke or Bake, or however you say his name. Everybody says that differently too. That's sort of an old classic. Gratz v. Bollinger, the sister case to Grutter, where the University of Michigan undergraduate process was found to be unconstitutional and did not pass strict scrutiny because it actually applied a significant number of just points, which really tipped people over to being admitted. Grutter, of course, and then the Fisher cases, which we decided to, after some expert advice, we decided to put together as one because they sort of are hand in glove. And then the issues, these are the issues in this case. Should Grutter be overturned and hold that institutions of higher education cannot use race as a factor in admissions? So there's the question of stare decisis. It's right there in the first issue. Should we overturn this case? And then if we don't just say it can't be used, then the second question becomes, does UNC's admissions process violate the Equal Protection Clause? So those are the issues the students will be delving into. So we like to do a little activity called classifying arguments. When you actually download the case summary, the next section will be arguments for the petitioner, Students for Fair Admissions, and will be a bulleted list of all of the arguments, not all of the arguments, the primary arguments of Students for Fair Admissions. And then it will say arguments for UNC, and it will have UNC's arguments. Again, these are their arguments. Sometimes we actually quote from them. A lot of times we have to paraphrase and make them a little more accessible to students, but they are the arguments in the briefs. But we love this activity. Again, I don't expect you to be able to read this, but just notice that these are these arguments, but they are randomized, and then they have a line afterwards. And the instructions, if you could actually read them, would say this: to read each argument and then decide if it helps Students for Fair Admissions or if it helps University of North Carolina. And this is, of course, to get students to really have to dig into the arguments and say, what do they show? So we're going to do a couple just really quickly together. So if you want to play along in chat, you're welcome to. If you don't, that's okay too. You can just think. So here's our first one. So, and you could just drop in the chat if you SFFA, if you think it helps them, or UNC if you think it helps UNC. Stare decisis is a core principle of the US legal system. To overrule precedent, a decision must be grievously or egregiously wrong. This requires something over and above the belief that the precedent was wrongly decided. I'm going to check my chat. Okay, we have a couple UNCs. Oh, now we have a flood of UNCs. Yes, definitely.
Wonderful. For the next one, should we do the chat waterfall? Everybody, you can type it in the chat. You hold it, and then when Kathy says go, we'll see that way. Can't all cheat off Bob Fenster here, right?
Okay, here we go. Stare decisis is not a binding rule. When a decision undermines the fundamental principle of equal protection, it is the principle, not the decision, that must win out. So hold them, type them, but don't hit send. Okay, send. Oh, beautiful. Yes. So a lot of times I made this really kind of easy for us because I knew I wouldn't have a lot of time for you all to like ponder it. But a lot of times there will be those sort of equal and opposite arguments like that. Not always, it doesn't always work. But, you know, when we can find sort of the counterpart argument, we'll certainly include them. Okay, well, waterfall again. So type but don't send. Grutter v. Bollinger should be overruled. It abandoned the race-neutral principles that the decisions in Brown v. Board of Education and Title VI set out. In Brown, the court held that the Constitution denies any authority to use race as a factor in affording educational opportunities. Yet because of Grutter, universities exercise that authority every day. Okay, waterfall. That just took me a long time to read that. By the way, I'm reading because I know some people are using really small devices. I know you all can read. Okay, beautiful. Yes, definitely SFFA. I wanted to use that one as an example because you can see how in arguments people are applying precedents. And I know for my AP peeps out there, applying precedents to current cases is a skill you need to hone. Okay, I love this too because it's a federalism issue. Some states have chosen to end consideration of race in universities' admissions. Under the United States federalist system, that is their choice. However, in many states, the people and their representatives continue to allow consideration of race in the admissions process. The Supreme Court should not intrude on this ongoing process of democratic decision-making. Okay, waterfalls. Beautiful. Okay. Okay, so I just would mention that there's a cut and sort option. So even really advanced students like to have tactile things where they can sort of manipulate things. So one thing that always works well on this, even with teachers, when we train teachers, is to enlarge the arguments and then cut them up and then have them physically sort them into piles. So I used an old picture from McDonald v. Chicago, sorry, but I didn't have any for the new cases, but they would sort them into a pile for SFFA and for UNC. And then the beauty of that is that the groups that finish early can then order them in from what they find the most compelling issue at the top to the least compelling issue. And then if you're going to go on to do another activity like a moot court, they've already basically have an outline of their argument, because they have, this is what I think the most compelling issue is down to the least. And they can also sort of look at them side by side and say, I find this more compelling. I find this pile more compelling.
And what a fantastic way to get your students not only up and moving, but talking to each other, right? To have them discussing with a partner, with a small group, here's why I think that reasoning is more compelling than other reasoning. So
right.
we're working on skills far beyond just, can I analyze this case?
Right. And don't worry about the fact that they don't have it on paper, because they'll all just take their phones out and take a picture of it. So, and then they'll carry it around with them. So then that always leads to a good discussion where you ask students, what should the Supreme Court decide? And if you really see the court itself, you can also ask them, what will the court decide, based on the makeup of this court, which can be very different answers, right? But we're going to do what should the court decide right now. So you don't have to waterfall this because there's no right or wrong answer. So the question is, should the Supreme Court overrule Grutter v. Bollinger and hold that institutions of higher education cannot use race? So only if you want to, because I know your name is attached to it. If you want to register what you think the court should do in the chat, feel free. If you don't, that's completely understandable. And I would mention that you could follow this up with the judicial opinion writing activity, where you actually have students then write an opinion. So we find that yes, the petition we find for the petitioner, and these are the reasons why. And those classifying arguments activities can be those reasons. These cases, including the Harvard case, are in the SCOTUS in the Classroom part of our website, and there will be more added. I'll tell you, give you a sneak peek of what the next one is in just a second. We also have links here to the other resources I'm going to tell you about in a second. So Harvard is there. The big difference in Harvard is the addition in the background to why this applies to Harvard, which I already talked about. And then the facts in Harvard are different. Their admissions processes. Of course, we encourage people to do moot courts. This is a picture of teachers at Georgetown University Law Center a couple years ago before the pandemic, mooting a case, so you get a feel for what we're talking about. And I think Dave did a good job explaining it earlier. We have recently revised our classroom guide to moot courts, and it's free to download now. You used to have to buy it. And so you can see that lesson 9 is the moot court, and it will give you all the instructions for these handouts, and this is how to prepare your justices, this is how to prepare your advocates. You'll see the judicial opinion writing activity is there as well. And a little thing called moot court. So Dave mentioned giving his students other activities to do, like writing amicus briefs. Some people have them be court artists or court reporters, but some people are concerned with moots that not everybody is participating. So we like to advocate for a mini moot activity, and someone is dropping all these links like a champ in there, so I appreciate that. Thank you. For mini moots, we have directions, and then we have this short video that's a screenshot of that shows you exactly how to do it. But essentially, you have 1 or 2 justices, 1 or 2 advocates for both sides. The whole room are mooting the case at the same time, and they're having these little discussions, these little moots. And that way, everybody is active. There's no way to get away from it. There's no place to hide. And so a lot of teachers really like that. And it's kind of fun to see how the different courts found different answers to the decision. I know I only have 1 second left, so I'm just going to cram this in. The next case is going to be 303 Creative, which is a lot of people are calling Masterpiece Cake Shop Part 2. We're really not going to advocate for people to moot this case because it deals with sort of some students' core identities, but we're going to give you lots of other ideas of activities to do with this case. This is my last shot at indoctrinating you. So for 2 seconds, if you want to know what we're up to at Street Law, a really good way to do that is to follow us on social media or to sign up for our educator updates. That's all being dropped as well and will be in your email so you know what we're doing. And last but not least, and I know we have at least one alumna in here. I see Cheryl. I don't know if we have some others. Oh, I think Bob too, maybe. But the Supreme Court Summer Institute for Teachers will be in those weeks in June. And it's a chance to have a really deep dive into the Supreme Court. And in 2002, I was a teacher at the Supreme Court Summer Institute, which is how I got hooked on street law in the first place and ended up working there 16 years later. Okay, I'm done.
Kathy, it looks like we have a number of
we do. Oh, Matt's here.
Yes, we got Matt. We've got Chris. We got all sorts of folks.
Excellent. Yeah, I might have advertised this on the Supreme Court Summer Institute alumni page. So
there you go. Well, I mean, that's a great place to find teachers who are interested in teaching about the Supreme Court, for sure.